themselves. First things first,
Yeah.
that would have compromised the quorum of the Supreme Court, and we don't have any other apex court.
Well, I'm not sure about the quorum when you say about the quorum, because there are 7 judges, and whether the Supreme Court will sit full 7-bench judge to make a decision, or they can agree to have a 3-judge bench to hear a matter. It depends on its veracity, the weight it has, and the way, you know, the public notoriety and the interest in the matter by the country. But if you talk about that the Judicial Service Commission did not hear a matter, you see, we are talking about the Supreme Court, Ben Troy. We are talking about the Supreme Court. We're not talking about the Judicial Service Commission. That is another independent institution, a great one, of course, but it's independent. It's not the Supreme Court. Now, whether the Judicial Service Commission has heard and determined whether a petition filed by Aluchier should be heard, whether it has been processed. And by the way, I support the aspect of Aluchier saying that his petition should have been heard by the Judicial Service Commission. The delay at the Judicial Service Commission is not excusable. I mean, they should hear the petition, and by now determine that it is true the 2-3 judges that Aluchier is complaining about are above board. You know, they are clean. Because the real issue here is every time to try to present judges as men and women who are honest, forthright, and bent towards justice. So that petition honestly should have been heard. There is no excuse why the JSC, you know, cannot hear the petition. But Ben Troy, before you cut me short, now, the Supreme Court is independent of the JSC. Even though those judges sit in the Supreme Court, some of them, still, in order for you to understand the germane issue about being independent, a judge is independent. Even if a judge is your relative, let's be honest about this, and he's going to sit a case probably that involves your family or something like that, the principles governing a judge when he's going to sit, listen, and understand is fairness, honest, and forthrightness. So whether the judge has been alleged to have done something, and he has been reported to the JSC, the tenets of fairness and justice demand that when he sits to listen, according to the doctrine of duty to sit and listen to a matter, he should pray to God if he's a prayerful person. He should completely divorce any interest he may have in a matter so that he's independent. And that independence is what we want to see in the Supreme Court, regardless of whether the JSC has handled these judges or not. I'm actually happy they have thrown out that request that judges recuse themselves. Judges have a duty to sit. And by the way, Ben, when you go before a judge, you look at him like this, you do your submissions. You can tell whether this judge is interested in fairness and, you know, justice, or he wants to bend justice towards. So it is important that Aluchier understands that, yes, he has lost that application. I don't think it's anything to go home crying about. The judges must be independent. And we will see that during both the proceedings and the outcome of the case. Actually,
very interesting, because the DCJ, Philomena Mwilu, is the one who has read that ruling, talking about, well, Aluchier has not provided any evidence to show that these judges could be compromised, or these judges might not actually give a fair trial. But anyway, as you said, it's an interesting thing. It's not something to go home crying about. But there's also, they're talking about, they didn't receive any petition on the same, which of course raises a lot of issues where he filed that petition.
No, I think
what are the evidence that he has that these judges could will not hear us or not give us a fair
I think
trial.
that's a flimsy, a statement to say that Aluchier filed a petition at the Judicial Service Commission, and the Commission says they never received, or the Supreme Court judges decided to say they've not heard about it or seen it. I know that we live in a strict legal environment. We are not like in the liberal Americas, where actually you would be accused and the accuser is believed, first and foremost. Here in the Commonwealth and in Kenya particularly, everybody is legalistic. We know that, I mean, Aluchel filed the petition, but probably the commission, the commissioners themselves have not been given the petition. I mean, that is an internal issue, and they must resolve it as a JSC. If you file a matter and it's not brought forward to the to the commissioner in charge of receiving the complaints, and then directed that the secretariat goes on, to prepare photocopies and present it to the commissioners, that is the internal problem. I don't think any serious commissioner should come on television and say we've not received it. Yes. It is upon you. When you hear that a person you call on in charge the secretariat, you call even the secretariat, the front office, and confirm if it is. That's now what we call real working. So it was filed. I believe Aluchel when he says it was filed. How it was not brought to light, amongst commissioners, that's an issue which is internal, and it should be handled for future so that no citizen files a complaint. Because you see, the impression now which will be created in ordinary minds is that if you file a complaint, it will disappear to the thin air, and that should not be accepted.
Indeed.
Within the JSC.
And Council, the first thing they've done is that they've consolidated the 3 petitions. Each petitioner had brought about his or her own issues. Talk about IEBC, talk about the Attorney General, talk about Raila Odinga. We are having 3 petitions. Everyone is pulling or pushing on his own side, but now they have been consolidated. Will that give each and every party a fair and a good hearing, if I may say so?
Yeah, that is how it works in litigation. If you look at the courts, I mean, they look at what is contained in this petition, what is contained in this application, what is contained in this other petition. And that's why you will see that at a certain time during the stages of hearing of a case, the judge might decide, no, I'm not going to hear any application now. I want us to go straight to the main case. So that you save on time and you capture all the dispute items comprehensively. If you look at what Raila Odinga is complaining about, and you look at what Uhuru Kenyatta is complaining about, and you look at what IBC as an institution is probably saying, I mean, we will go on and do our mandate as a, to spell out what boundary will be where. That is squarely a mandate of IBC. Uhuru Kenyatta will be wondering, I mean, you've not even given me a chance to be heard, and you've made elaborate pronouncements about me.
Yes.
You see, this is more, in my humble view, a more smaller matter. Like a person is really trying to defend himself so that he's not judged wrongly. But as a president, again, it will be a bigger issue because it relates to how the presidents in the country will be handled. Now, you talk about Raila, he's saying, look, I mean, we have started this BBI and we want it. So the judges look at all these things and say, no, we have to consolidate them to save on time. Because if you hear one petition after the other, one petition might require 2 months to be heard. Like, okay, fine, you've seen 3 days, these all matters will be heard. Yes. So one petition might require 3 days. And probably it will be a prerequisite. It will be a requirement that they first hear Raila's application or they hear IBC application and then proceed to the other one. So that's wisdom in litigation. I think the judges have considered all the issues and decided we will have all. And you remember that all these 3 applicants, petitioners, will actually canvass their matters the way it is in their petition. It is the judges who in a sense, will put that in one particular ruling or judgment. So it is not improper. It is actually the wise thing to do when petitions are arguing or are trying to propagate the same issue. It's important that they are all, joined together. Yes.
Of course, a loss for Isaac Aluchel, but a big win for the professors who wanted to be enjoined as amicus curiae. But the court has said, yes, we do value your presence, but we are not going to allow you to make any oral submissions. How are they going to be helpful if they're not allowed by the courts to submit their oral submissions?
Ben, I have to kind of correct you again. By the way, there's no loss for Aluchel. If you look at the fact that he, when you go to the court, you have got this burning desire. You want to help the country. You want to ensure that justice is achieved.
Yes.
The best way Aluchel thought that the country will be served is if the 3 judges are not on the bench.
Yes.
But being told, no, sorry, we will have to retain the 3 judges so that we can look at the case comprehensively and let them also give their opinion, because they have a duty to be judges. That means they have a duty to sit.
Yes.
So that is not a loss to him. I think he had a noble issue, a noble intention to ensure that justice is served by people who, according to his mind, were not tainted. So a refusal to accept to that request is not failure. It's not actually like he has lost. You know, we have propagated that level of jurisprudence now, where we know you can say, I don't want this judge so-and-so to sit, but the court might be having a different opinion. So there's no loss. Okay. Now, coming to the good professors who have been allowed to join in the proceedings. You know, this litigation thing, it has its own history. You know, what happens after the judgment is, written, and it is mentioned that Professor so-and-so sat in as amicus curiae. I do not know the judge's mind why they decided they cannot give any submissions. In my humble view, they would have probably, welcomed or allowed the professors to make very brief comments about, whatever it is, even within a span of 3 minutes or less. Yes. But you see, that is the wisdom of judges, and they have told them you can only sit in and listen. To me, I mean, they will honestly be, they have been reduced to just to spectate. But that again happens in our courts. You can be allowed to participate in the proceedings by being silent.
So, okay, perhaps to shed more light, how are they supposed to help? PNU also had made an application to be enjoined in the case, but the good judges have said, no, we are not going to allow a Party of National Unity to be enjoined in the suit. But the good professors are part of the hearings, but they will not make any submission. How are they supposed to make any additions? Or they are good professors. They have actually a lot to offer according to their CVs and what they had talked about. They were going to help in this case. How are they going to help if they cannot talk? You see, what is the point of actually having them there as spectators? Because as Kenyans, we will also be watching at home or we will be in the court listening, but we cannot help. No, it's not the same, Bentroy. Because you see, a professor sitting in the courtroom is probably sitting on the 2nd or 3rd bench within the same courtroom. Definitely he has people who have his views, or he shares views of some lawyers who are sitting in those pews. So, he has the chance to both listen and communicate with the rest of the lawyers, his views and sentiments. I remember I have sat in a courtroom, and one of very, respected lawyers in the country, and I will mention this is Feroz Naroji. He could see that I'm struggling to deliver certain submissions, and he knew the whole matter because it relates to political, political leadership. And he actually tapped me and he told me A, B, C, and I was amazed. So it is different when you are watching on television and sitting here to commentate like me, and somebody sitting in the courtroom and listening to the judges. There is a huge amount of support that you can offer your colleagues when you are in the courtroom. I do remember LSK President Nelson Harvey there, because CJ has talked about 15 pages for each and everyone who will be submitting, and of course they're supposed to file and the responses within what, I think it's 10 or 7 days. But he talked about 15 pages being quite small, wanted from 40 pages. Of course, we know the volumes that we have seen in courtrooms. We actually wonder when somebody is supposed to go through all those from 15 to 40, but of course the court was maintained that it's still 15 pages. Will that be sufficient?
You see,
the BBI from the High Court, the Court of Appeal?
You see, Bentroy, it's always good to be honest and forthright, because what is the use you give me 50 pages of write-up and I will not read it? I think judges who are very honest. Number two, the whole point about litigation is, can we find an ending to litigation? Can we have concise, summarized as much as possible, condensed type of submissions. And this is very difficult. But you know, Bantroy, before we became lawyers, we all did the usual summary and grammar in fourth form. I mean, you know, you read a whole comprehension and you're supposed to do about a paragraph or two to express what has happened in the paragraph. So one other way of being a very good lawyer is to know out of your bulk of emotions and wisdom, which one do you want to eject and discharge to the country? So it's not everything. So I think that 15 page, to be honest with you, I think 15 pages is not good enough. Maybe if they say 20 pages or 25, but again, that's my view. The view of the judges from where they sit and the time they have. I mean, you know, we are going to elections in a couple of months.
Yes.
Everybody's now mood is towards the election. So there's no time. So the judges have decided 3 days of hearing the matter. They want to read 15 pages from all the lawyers. That would amount to how many? We have, how many? 6 about lawyers. I mean, if you do times 15, still that's quite bulky kind of, you know, material to read. So I think they'll have to live with it and provide 15 pages, yes.
Yes, and the CJ has talked about 7 issues for determinations. Of course, it's something that came up during the Court of Appeal hearing, and they've talked about, of course, the basic structure doctrine is something that has been on the lips of so many, including you, the lawyers, when it comes to the BBI case. Of course, 7 issues up for determination, and the basic structure doctrine also coming up just the same way as it came up in the Court of Appeal.
Yes.
It's quite a pertinent issue when it comes to litigation in Kenya.
Yeah, I will, Bentro, I cannot speak about it now that the judges will speak about it first. And I think it was not only the basic structure, there are many other issues, like, for example, can the president be sued? Can the president initiate, you know, public participation of an important and major issue like changing the constitution of the country? And so on and so forth. So we will let the judges make their final finding, and then we come back to that particular point. But of course, we have 2 sides in a court of law. There will be those saying no, there is no basic doctrine, and that has been litigated now in the High Court and Court of Appeal. It has been, you know, upheld that there is in the constitution of this country a basic doctrine. Whether the Supreme Court thinks the same or they will vary that view is what we are highly all anticipating and waiting to hear, whether they will vary or they will retain it. And then now it will become law in the country, yes.
Of course, without going to the specifics of the merits of the case, because it's already now in court, something that a lot has come up, and especially at the Court of Appeal. We can at least talk about some of the decisions that came up at the Court of Appeal, which led us to the Supreme Court, and especially when it comes to IEBC and the quorum itself. And very well, they did note that there was not enough quorum when it comes to IEBC. Could that perhaps form basis for challenging of any decision that IEBC has done, including the voter registration that we've just concluded?
Yeah. I don't know, Bentray, but I still do not want to comment deeply into the validity or none of the Court of Appeal judgment, because first of all, I don't want to support those who feel that the country should not be together, it should be divided, or those who feel that so-and-so should be president and not so-and-so. So I will leave that first to see the Supreme Court, and we are here, Ben. We can come back.
Actually, we need to go back there because I hear my director informs me that they are actually planning to go back. Remember? Yes, indeed, we are live from Broadcasting House here in the county of Nairobi, and also we were live from the Supreme Court of Kenya right here in the capital, Nairobi, and the CJ Martha Koome has just given the directions that the BBI appeal case will take at the Supreme Court. And perhaps to add on some of the things that she had just talked about is that, of course, first they had talked about 15 pages for written submissions, and now they have scaled it up to 28 pages, but with a catch, 20 minutes for each submissions. And they've talked about of course, ensuring that each and every party is well prepared so that from 18th to the 20th, when the case will be heard in January of 2022, each and every party will be prepared for all the submissions. And of course, before we crossed over to the Supreme Court, I am with Ishmael Nyaribo, who is a constitutional lawyer and also a governance expert. And perhaps, counsel, the CJ has talked about weighty constitutional matters. I think this is one of the biggest cases that the Supreme Court has had to listen to.
Yeah, if you look at the time since the promulgation of the Constitution of Kenya, I think this is the first case that now has heavily litigated on the content of the Constitution of Kenya. And I think you can see that there was quite, heated arguments in the High Court and in the lower court, in the Court of Appeal. So yes, the cases raise heavy, weighty, and complex issues to be handled. But as I said, they all point out to one item, whether the BBI ought to have been allowed to commence under the tutorship of Raila Odinga and Uhuru Kenyatta. Indeed, whether it was supposed to be done under Uhuru Kenyatta. In terms of Raila Odinga, it's neither here nor there because he wasn't holding a public office. So that is one. And the other issue is the powers of the president and whether he can be sued in civil courts when still sitting in office. That's again another issue that needs to be looked at. The extent of public participation. I mean, is it enough to say that we have sent the document to the counties? And by the way, what will happen to involvement of all the 47 county assemblies in this matter? Did that amount to public participation, or it was just a hoodwink? I mean, there are several issues being raised by these petitions. But Ben, you will see that the CJ has actually come back. And I like this CJ. Honestly, look at, flexibility. I mean, we are misunderstood as lawyers, like we are straitjackets. We cannot look around when we are talking. We are misunderstood as lawyers. And the judges are also now mostly misunderstood. But look at the CJ. She has come back. They say 20 pages. Now she has opened it up to 28 pages. I have seen Senior Counsel Oraro addressing her on the timelines. I mean, 20 minutes again to address you on a 20-page submission. That means I have less than 45 seconds to cover every page. This is not normal in our African context, Ben. So, and she said, I heard her say that I think actual timelines will be set during the when they appear before the court on the 3 days in February or January?
In January.
In January, yeah. So yes, it is a complex kind of case. It raises complex issues, and I think many of them will be. If this is the spirit and the attitude that we have from the Supreme Court, it means they are not predetermined. They've not decided whether this case will go right or left. They will be listening to the lawyers. They will be listening to the litigants, and then make a finding. Yes, indeed.
And it's a good thing you've mentioned the county assemblies, and of course the bill did sail through Parliament as well and Senate. And something that came up at the Court of Appeal is that there was no adequate framework. There was never a referendum. Bill was still gathering dust at Parliament. Perhaps away from the courts, was that a failure by Parliament?
Well, you see, I think President Kenyatta and Raila Odinga actually rushed the whole stuff so that they can achieve a certain end. Raila says the end was meant to unify the country. The president has also said his intentions were noble. As president, he wanted to ensure that he leaves Kenya united than disintegrated. And I don't think the High Court and the Court of Appeal critiqued the intention of the president and the former Prime Minister Raila Odinga. No, I think the High Court and Court of Appeal have not come closer to dictating what Kenyans want to do in terms of the content that they want to put into the Constitution. This is not, this may of course, some comments here and there, you're referring to that. But the main issue the main dispute, the main bone of contention by the judges against Raila Odinga and Uhuru Kenyatta was the process used. I mean, do you shake hands and then create a secretariat and then say, we now can collect views and we can put these views into the Constitution of Kenya? Bentro, this is the issue. And I think this is where now the Supreme Court wants to go and elaborate whether, yes, can people shake hands? Can they set up a secretariat? Can the secretariat go out there, collect signatures, and come back and say, now we have the people's views, and the views are here contained in a document that was passed through the county assemblies and the National Assembly. So I think the National Assembly, if they really were listening to their principal leaders, they should have done something. Whether that's something they would have done in Parliament to sanctify the whole process. Now, you see, it was not done, Ben, so I can't say whether, if they did, would the courts have also sanctified the process? So that didn't happen.
Yes.
And I don't want to say it's a failure. I don't know, you know, that's Parliament, they didn't do it. The county assemblies did their part, so I do not know. I don't have an opinion on that strongly. No, I don't have. But what I think is the Supreme Court will address each and every item that has been raised in the High Court and the Supreme Court. Yes.
And without going to the merits of the case, they raised a substantive question whether the president can initiate the constitutional amendment process through Article 256, which is, of course, the Wanjiku style, other than the 257 of the Parliament. But at the end of the day, somebody can argue the president first is a Kenyan, and then he is a president. So he could have used that route to explore the options of constitutional amendment.
So, Betray, again, as an advocate of the High Court, I will tell you, again, we want to give the Supreme Court judges a chance to make a determination on that before we can comment about it. Also, my colleagues, many of them senior colleagues, are going to litigate on that. So it will be too much to try to throw, statements ahead of what they are going to say. Probably we just reserve those comments in terms of whether the president can be sued or he cannot be sued, whether the president can initiate a national referendum. If you ask for my personal opinion, somewhere away from the national television, I honestly have my own opinion about that, whether he can start or he cannot start. But for sake of good order and orderliness, we will wait. Once the judges give us a judgment, then we can come here and we critique that judgment the way we want. And now we are also in a way hands tied to comment about the Court of Appeal, judgment in detail when the Supreme Court now has assisted itself of the matter. I think we can wait. February is not so far, and we can come back and argue about
actually January.
January is not so far.
By the end of January. Okay, thanks for that. But at the end of the day, I have seen so many senior counsels there. I've seen some distinguished lawyers. We've had even the good professors, like Rosalind Dixon, have been also added into the mix. But who is representing Wanjiku? I'm a viewer at home. Who is representing my interest there? Because at the end of the day, BBI was supposed to unify and touch all Kenyans, whether somebody supported it or not.
Ben, I just mentioned to you before that every legal expert going to the court, to be very clear, is representing the public, really. I mean, yes, he may have interests of Raila Odinga, have interests of President Uhuru Kenyatta, or have the interests of Katiba Institute. But when you look at all these arguments, they are actually propagating the views of the ordinary Kenyan. If you remember, in 2017, when Justice Maraga and his Supreme Court nullified the elections of the presidential elections, I mean, everybody was jumping up and down and feeling like, yes, we are represented by this kind of judgment. The same way here in this arrangement today, every lawyer arguing in court is trying to look for fairness and justice. So really is representing the ordinary person. But look at the Law Society of Kenya. It is, the law requires that they represent the citizenry. They, advise the government on law. They advise its members on what to do on law and empower them to, do proper litigations so that justice can be served at the end of the day. So with the Law Society of Kenya really being there, the president himself is representing, his clients. I don't think that the public is exposed. The public is properly represented, yes.
Indeed. And looking at perhaps beginning with the nullification of the 2017 general election and looking at how the BBI process has gone through into the country, what would you say of the jurisprudence in Kenya? Because the Kenyan situation is being used by other nations now since when the elections were nullified to date. And Kenya has been hailed as quite matured in terms of our constitutional litigations.
Yeah, one of the questions Ben, they asked the judges when they were the people they were interviewing for Chief Justice. One of the questions was a curious question. They actually asked, "What will you do to try to grow the indigenous jurisprudence?" That means the local trends in the country in trying to fuse them into a very much Western-based kind of jurisprudence. You see, when you go to court, they are not going to quote Nyaigoti, of my village. They are not going to cite rarely do you hear people citing the local, persons.
Like the way we used to hear the Muruatetu case.
Exactly.
Yes.
No, okay. But Muruatetu case was decided, heavily on principles borrowed from outside the country.
Oh, okay.
I mean, you will hear, Lord Denning, you will hear people mentioning several other judges outside the jurisdiction of Kenya. I think that the case of Justice Maraga, where he nullified the elections of this country, especially the presidential elections, is heavy and has been cited all over the globe. I am one of those people actually who are hoping that we can come to a level where we are able to cite our own local cases, so that we grow our law based not necessarily on what is happening in England or in the United States or in South Africa. And I know that the nature of law practice, the nature of litigation, you cannot be an island of yourself. But if you look at the Indian jurisprudence and Indian litigations, they heavily rely on what their own courts have said before. And this takes me to how our judgments look like. I mean, in Kenya, you still have one judge saying a particular case, a particular statement and a finding. And then you have another judge of the same level, which we call concurrent jurisdiction.
Yes.
Saying something which is actually opposite of what this other judge did say. So that means we've not grown our own jurisprudence to what they call a decidendi, statements that can be used by the other coming judges in the future to rely on. And I think that's a big gap. And I think it's what the JSC panelists at one time were asking. I remember them asking Justice, Chief Justice, what will you do to grow the indigenous jurisprudence? It's a gap that we still have in the country.
Indeed, and in case you just joined us, this is KBC News Check, and for the last about 1-2 hours, we have been having a live feed from the Supreme Court of Kenya, today being the mention date of the BBI appeal case at the Supreme Court. And in case you missed it, the case will be heard from the 18th, 19th, and 20th of January 2022, where they have talked about 28 pages for written submissions. And of course, the professors Rosaline Dixon, David Landau, and Gautam Bhatia had filed an application to be enjoined in the case. They have been enjoined in the case, but they are not allowed, or they will not be allowed to make oral submissions. Of course, they will be able to help out in one way or the other, as counsel has informed us. And also something else is that the application by Isaac Aluchiel has been struck out, where he wanted 3 of the judges to recast themselves from the case. And of course, the 3 petitions have been enjoined, and now they will be heard as one application. We're taking a quick break. This is KBC News Check.
Yeah.